And then he comes and tell her, if you're really that mad at me, then hit me. And that's when she went to him and hit him twice. Boom, boom.
How is it fair that I find probable cause on him and not on her? Why didn't they charge her?
Hey there, welcome to the Courtroom Files. So in this interaction from Judge Fleischer's court, we have a family violence situation, and the judge asks two very important questions that I don't have the answer to, but I present this to you for you to answer them. Number one, should the other combatant in this situation have been charged as well? And number two, did that other person get preferential treatment and not get charged because it was a woman? He asked those questions. I'd like to know what your thoughts are on the matter, so please do let me know in the comments after you watch the whole video. Please put a thumbs up on it if you enjoy it. Consider subscribing to the channel if you haven't already, and let's go ahead and roll the game film.
Sir, you want to talk to me while we're waiting?
Oh, yes, sir, we can.
We just have that Sullivan.
You wanted to do a proper cause on Mr. Sullivan?
To be quite frank with you, I don't even remember what happened. It's an
The
assault.
allegation, let the state.
Yeah, so-
tell you.
I'll just read you the PC summary again. So on March 23rd, 2025, in Harris County, Texas, officer was dispatched to a servant's call and met with the complainant witness, stated that the defendant is her husband. The complainant witness stated that she told the defendant that she was going to move back to Arizona that day, and they got into an argument. The defendant then told the complainant witness to hit him in the face. Complainant witness then struck him in the face 3 times.
Right.
Complainant witness then stated 10 minutes later, she went into the bedroom where the defendant then laid down on top of her, grabbing her wrists, causing pain.
Oh, that's 10 minutes
That's
later.
10 minutes later. Grabbing her wrist, causing pain. Complainant witness then got one arm loose, grabbed the defendant's genitals, causing him to let go. And then the defendant then struck the complainant witness in the mouth, causing pain. And the officer observed the complainant witness to have bruises on her arms and injuries to her top and bottom lip.
How is it?
I think we are omitting some things that's pertinent to the decision that you're gonna make.
What?
That she asked, she or her daughter told her that you have to make a choice between
Oh, that's right. Yeah. I
and
remember. And then she makes a choice of him.
and she said, I'm leaving you and I'm going to be with my daughter and grandchild. And then he comes and tell her, if you're really that mad at me, then hit me. And that's when she went to him and hit him twice. Boom, boom.
How is it fair that I find probable cause on him and not on her? Why didn't they charge her?
So I would say one is the fact that he quite literally says to hit her or to hit him.
Can't consent
Well,
to,
but that's, I
consent
mean-
to an offense, Judge. If
Well,
he
you can't
tells me
consent
to
to
shoot
assault.
me,
Yeah, no. I mean, you can, like,
Yeah.
boxers consent to
You can
assault,
consent to
right?
assault. That's.
But I mean, in this,
I think where we are for PC purposes, as far as this offense goes, is that it occurs 10 minutes later. Then we have essentially in a situation where he can't essentially claim self-defense if he's the one being the aggressor first, where he's grabbing her 10 minutes after this kind of initial incident happened. He's grabbing her, then she grabs his genitals, and then he punches her in the face. I think that's where we're at as far as PC goes.
I don't think that's the law, Judge. I don't think you can avoid what had happened earlier just because it was 10 minutes later. I don't think you can take the fact away that she was the one that instigated and was the culprit of the initial assault.
but there's a long cooling down period. You know, if it's like maybe a minute or two after the fact.
I would say.
And then, but nevertheless, though, how's it
still
fair that she's
assaulted.
not charged? I mean, why does she get the benefit of the doubt? Because she's wearing a skirt.
I mean, the code does say you can consent to an assault.
If you consent to, if you tell me to shoot you and I kill you, you don't think the cop's gonna get me for murder?
Well, you can't consent if there's serious bodily injury involved. You can't consent if there's no threat or actual serious.
Come up,
bodily
Mr. Sullivan.
It's less than the serious.
I mean, an assault does occur in this case with him and her, but there's also another one that
Right.
occurs, you know, so.
I would argue, Judge, that at this point, with the charge that we have, that's going to be fact issues that I'm sure we're going to parse through moving forward, but I think that's.
And I think it'll work to the benefit, you know. So, Mr. Sullivan, I'm going to find that there's sufficient probable cause to go forward with your case. don't have any contact with this person, please. The only thing I'm going to ask you to do is don't pick up any new cases, don't have contact, and don't be possessing weapons. I don't know why they didn't charge the other person. I don't understand. And I don't know. But be it as it may, just don't have contact with this person. I think that, it's just could be like a rumbling volcano. And the last thing we want to do is we don't want anything more to erupt. We don't want further charges and just, and I think that, they'll take it into account when you guys are talking about this case, but just stay away. That's all I'm asking you to do. Okay.
But Judge, with all due respect, I don't think it's too late to not to file charges against that person. I mean, I've seen cases where there are 5 charges.
That's not me. That's up to the DA's office and intake whether they.
Then I think the DA's office should take that in advisement to file charges against the person who was the actual initiator of the contact between these parties. If they do it all the time, I've seen cases where the district attorney filed cases 1 year later, when they know that there's evidence to substantiate the filing of a charge against somebody.
Who knows? Maybe it will. I don't know. Do you mind filing no contact, no weapons? I've given you a lawyer. All you'd have to do is just stay in contact with Mr. Dixon. He'll tell you if and when you have to come back to court. I'm going to waive your appearance so you don't have to waste your time coming to court. Just stay in contact with him and he'll tell you if and when you have to come back. Don't leave until you sign the bond conditions. Once you sign them, you're free to go.
If I run out, I gotta put some money.
Go.
money on my-
Take your time. But just come back.
Okay, I will. Thank you, sir.
Thank you.
Take care, sir.
Hey, thanks for watching. If you enjoyed that video, do please take a moment to like, subscribe, and leave a comment on the video. We'd really appreciate that. And if you want to keep the fun going, check out the video on the screen right now.